Hey everyone, how you doing? Bobby Sawyer here with Johannes Meyer and Sawyer. Welcome back to our probate case study series. Today we're diving into a situation that unfortunately comes up more than people realize. When probate is opened as a small estate, but the real assets are worth over $1 million. This one involves a Maryland intestate estate. That means no will. The person who passed away didn't have a will, with a major Boy Scouts of America lawsuit settlement as the primary asset. We're keeping everything fully anonymized for privacy, but the facts are real, and they highlight some serious red flags that any heir or executor should be on the lookout for. But before we get into the details, I'm a lawyer, so got to do the lawyer stuff. Most likely, I'm not licensed in your state. I am not your attorney. And if you have any legal questions, you should consult with an attorney actually licensed in your state. If during the course of this live stream you have a question or issue, please pop it into the chat. I'll try to answer it. If not, I'll follow up with it later on. All right. Results may vary. Let's jump into the fact pattern, shall we? Picture this. Father passes away in Maryland on February 9th, 2026. He dies without a will, intestate, so Maryland's intestate succession laws apply. That means his children are his primary heirs and would normally share the estate assets equally. Now, if he were married, that'd be a different story, but he was unmarried at the time when he passed away. The family had been through a lot. The decedent had won a significant settlement from the Boy Scouts of America valued at approximately $1.6 million. Before he passed, he had told all his sons that he wanted split equally among his sons, or split equally among them. Probate is opened about 2 months later on April 7th. But here's where things get concerning. The estate is filed as a small estate, claiming the probate assets are under $50,000. In Maryland, that simplified process is meant for truly modest estates, and it has much lighter requirements and oversight from the courts. One of the sons, we'll call him the alleged administrator, appoints himself as administrator. He's claiming to be his son, but paternity is questionable. Never been confirmed with DNA, and there's no clear proof on the birth certificate. Meanwhile, there are at least 3 confirmed sons who were never properly notified. So, February 9th, death. April 7th, probate opened as a small estate, under $50,000, as opposed to the true value of the estate, which is $1.6 million. So why does this matter? Because a small estate proceeding in Maryland is designed for estates under $50,000. And when the primary asset is a $1.6 million settlement, that filing is alleged to be a significant misrepresentation to the court. Well, what happens in a small estate case? Well, there's much less court supervision, fewer formal notices, and faster but less transparent handling. By filing in this way, the other confirmed heirs say they were never given proper notice of the appointment, their addresses were allegedly listed incorrectly, and they had no chance to object before the administrator took control. The confirmed son who called us, one of the rightful heirs, told us his father explicitly wanted the settlement shared among him and his other siblings. Now he's worried that the estate isn't properly administered, that funds could be at risk, and that the administrator may have acted in bad faith. Here's some additional red flags that we saw. Paternity of the administrator is disputed with no confirmation. Alleged substance abuse concerns that could affect handling of large sums. And no other assets listed, even though the settlement is clearly the main asset. So here's some client questions and how we responded to them. He had some very specific questions, and they're questions we hear a lot in contested estates. First one, how can someone just appoint themselves administrator without telling the rest of the family? In Maryland, when someone files probate, they're supposed to notify all interested parties, the known heirs. If addresses were allegedly submitted incorrectly or heirs were omitted, that's a serious issue that can be grounds to challenge the appointment. Next question. Does the estate really qualify as small when the main asset is over $1.6 million? We explained that the classification is based on the value of the probate assets at death. If the filing understates the value to qualify for the simplified process, the court can and should be asked to reclassify it as a regular estate with full oversight. Can the administrator be removed? Absolutely possible. Maryland courts have authority to remove a personal representative for misconduct, misrepresentation, or failure to act in the best interest of the estate and heirs. The caller wants a neutral third-party administrator appointed to ensure fair distribution of the assets. Our solution and what happens next. Here's how we approach it with the family. Number one, review all the court filings and the settlement documentation to build a clear record of the actual estate value. Number two, prepare a petition to challenge the administrator's appointment and request removal. Number three, ask the court to reclassify the estate from a small to regular probate for proper oversight. And number four, seek appointment of a neutral third-party administrator who has no personal stake in the outcome. And finally, ensure proper notice goes out to all confirmed heirs and that the distribution follows Maryland intestate law, equal shares among the children. Because the family is already in active dispute, moving quickly is important to protect the funds and prevent any further issues. The goal is fair, lawful distribution to everyone the decedent wanted to provide for. So, what are the big takeaways and lessons from this case study? One, always verify the estate value. A small estate filing that hides large assets be challenged and reclassified. Two, proper notice to all heirs is not optional. If you're an heir and you never received notice, you still have rights to object. Number three, disputed paternity or self-appointing without transparency is a major red flag. Courts take fiduciary duties seriously. And here's a pro tip for anyone dealing with probate right now. Keep copies of every filing, communicate in writing, and don't hesitate to ask the court or register of wills for the full file. If something feels off, get experienced counsel involved early. Like I said before, today's case study has been anonymized. These situations are why we do the live streams, to help families spot issues before they become bigger problems. If you're an executor, heir, or just someone who's seen something similar in your own family, drop your questions in the chat and I'll answer them as I can, or I'll flip separately. Next episode, we'll dive into another case study. But these probate case studies, there's one underlying theme, or one big takeaway everyone should have here, is that a lot of these things can be avoided with proper planning. If you get a proper trust in place and it's properly funded, you can avoid the probate process entirely. And all these sort of stressful times that families go through can be avoided with a little bit of advanced planning. So, hope everyone's enjoyed today's case study. But final reminder: this is educational purposes only, not legal advice for your situation. I am not your attorney. Most likely, I'm not even licensed in your state. So if you have a specific legal question, please reach out to an attorney licensed in your state. We do currently operate in Alabama, Maryland, North Carolina, South Carolina, and Tennessee. Again, hope everyone's enjoyed it. Have a great weekend. It's Friday if you're watching this live. And we're here to answer your questions. It's Bobby Sawyer with Johannes, Meyer, and Sawyer. Thanks.